From Russia, let's turn back to what we know of the Mueller report and look at a number of legal questions the Attorney General's letter has sparked. With Neil Katyal, he was acting U.S. Solicitor General in the Obama administration, and Paul McNulty. He served as Deputy Attorney General in the George W. Bush administration, and before that served as spokesperson for Attorney General William Barr in his first time in the job during the first Bush administration. We thank you both for being with us. I want to ask you first, based on what we know, both sides are drawing their own conclusions about this very brief summary from the Attorney General of the Mueller report. What do you make of this, Neil Katyal?
Well, I think you're right, it's a brief summary, but it's a very troubling summary. And I think the most important thing, and this is what I wrote about in today's New York Times, is Barr's conclusion about obstruction of justice. Remember, Mueller spent 22 months investigating this. He didn't reach a conclusion. He laid out in his report the evidence from both sides, presumably for Congress to evaluate. And then the Attorney General goes and swoops in within 48 hours and says, oh, I've decided there's no obstruction of justice here. There's not enough evidence. And maybe maybe hearkening back to his his 19-page memo from the summer last year, who knows? But this raises far more questions than it answers, and it just underscores why we all really need to see the Mueller report.
Paul McNulty, let's then start with the question of obstruction of justice. But let me ask you first, what about this notion that Robert Mueller spent 2 years on this and concluded he could not draw a conclusion? He couldn't come to a recommendation on obstruction of justice. What do you make of that?
Well, I think what Bob was doing there was pointing to the fact that a prosecutorial decision needed to be made. Apparently, he made arguments in his report for both sides of a decision, but recognized that the decision by the Department of Justice is one that it's made with the consultation with the Deputy Attorney General, the Attorney General, and other officials. And so he deferred to them to make that prosecutorial decision. That's why I think it goes well beyond any view that the Attorney General has with regard to obstruction of justice and goes to the question, most importantly, of proof beyond a reasonable doubt and whether or not the evidence and the law was going to meet the standard that DOJ has, that a reasonable juror would find beyond a reasonable doubt that obstruction of justice occurred.
And you're saying because that the Attorney General was comfortable saying that based on what Robert Mueller had.
Right, and I actually disagree with Neil's point earlier about the swooping in factor, because in the letter it says that the special counsel was in consultation with DOJ officials for quite some time about legal theory and facts associated with obstruction of justice. So Attorney General Barr probably had the benefit of OLC, the Office of Legal Counsel, criminal division lawyers who are career prosecutors, Rod Rosenstein, who has been involved in this all along and probably had a considerable amount of thoughts to bring to the issue. And all that together, they said that if you look at this summary of law and evidence, and this is the chief law enforcement officer,
right,
this just doesn't meet the standard. That's why I think they came to that conclusion.
Neil Katyal, you've been shaking your head.
Yeah, I couldn't disagree more with my friend Paul. So he's right to say that Mueller laid out both sides of the evidence. That's what we know from the Barr letter. But it's absolutely wrong to say that Mueller invited Barr or the Justice Department to reach their own determination. That is nowhere in the letter. Maybe it's in the report. I don't know, but I certainly don't know that. I don't know how he could know that. And now there have been leaks from the Justice Department today that have said, oh, well, Mueller had given a 3-week heads up to Attorney General Barr that he wasn't going to reach a conclusion. And again, that's nice, and maybe that allows for some legal debate with the Office of Legal Counsel. But remember, Barr's letter yesterday said there was not evidence that there was a corrupt intent, a corrupt motive on the part of Trump. And as far as I know, he only had 2 days since the Mueller report came in for him to reach that determination. That's a striking thing to do. 2 days, reached it after 22 months?
Just a quick response, Mr. McNulty.
Well, Neil, I just want to ask, maybe you and I are misreading this letter or why we disagree on this point. Doesn't it clearly say that the special counsel deferred to the Attorney General, to the Department of Justice, for this determination? That's all I was trying to say earlier.
Again, I don't think that's quite what it says. I think Barr is characterizing that we don't know whether Mueller thought that Congress would be the right decider here or the Attorney General. It's just not in that letter at all.
Well, we're not going to resolve that right here, but it's the two of you have clearly taken a look at it. But let's turn to the finding that there was no conspiracy, no coordination with the Russians. Neil Katyal, that seems like a pretty straightforward conclusion that the special counsel drew, at least according to this summary.
Straight and not. So, I think that there's been a lot, it's almost like the Bible or something. People are reading stuff in that's not in there. I mean, you just heard Kellyanne Conway just say to you that the report shows that, quote, the president did not try to interfere with the investigation, which of course is nowhere in the 4-page letter. And yes, there is a conclusion about collusion, but again, that's a criminal standard that Mueller was applying. And that's why, again, the report needs to come out, because there may be evidence short of that very high standard beyond a reasonable doubt that the American public needs to see. If there was no collusion, either criminal or civil or, a layperson's view, I think all of us should celebrate that and feel very, very pleased that Mueller reached that determination. It's just that I don't think, based on the four-page letter, that we can jump to that conclusion yet.
Paul McNulty, how much of the Mueller report does the public need to see, deserve to see, in order to answer these very tough questions?
Well, Judy, need and deserve, those are both good words, and I would say that there's definitely a case to be made for that, and certainly the interest level is sky high. One of the really challenging issues here, however, is this reference to grand jury material that is going to have to be resolved. Apparently, the report has a significant amount of information that was obtained through the use of the grand jury, and then that raises a question, because there are very clear rules about grand jury information, how that's going to be resolved so that the report can be released. That's going to be the big issue in the next several days.
A very short final question to both of you, and I'll start with you, Neil Katyal. How much vulnerability does the president still exist for the president, given these other investigations still underway in New York, in Virginia, and elsewhere?
I mean, huge. I mean, I think I've been saying for more than a year that the Southern District investigation poses a far greater threat to Donald Trump, because that's one in which he has been named individual number one as orchestrating the commission of 2 federal felonies. That is something that is almost never happened in the course of American history, to have federal prosecutors finger a sitting president of the United States as part of a conspiracy to evade federal law. That's a pretty striking thing. And so whatever happens with Mueller, this investigation is still going on.
And Paul McNulty, how do you read the president's vulnerability in these other investigations?
Well, I think Neil does identify some uncertainties about cases that have been spun off from this, and we'll have to see where they go. So it's clear that there are other issues out there. I think the attention has been focused on the collusion question, and that's going to probably, in the minds of voters, be a very significant factor that we're turning the page on that, as generally speaking, even though Congress is going to have a lot to say about that. But time will tell as to what else will emerge from those ancillary matters.
Paul McNulty, Neil Katyal, we thank you both.
Thank you.